On Tuesday, we looked at the Jules Helping Hands Division 3 appeal, a homeless advocacy group appealing a City of Spokane initiative aimed at cracking down on the homeless encampments within the city. The appellate court affirmed the previous decision, prompting Jules Helping Hands to argue their case in the Supreme Court in September of 2024. They again are arguing that this initiative seeks to exercise powers reserved solely for the Spokane Council, it conflicts with controlling state law, and is outside the scope of local initiative power because the measure is administrative and not legislative. Let's take a look at the arguments and the decision that was released just 2 weeks ago.
Thank you, Your Honor. May it please the Court. Noel Lowney representing the petitioners. We're asking the Court to reverse the Court of Appeals and hold that Spokane's homeless camping initiative exceeds the scope of the local initiative process. We ask the Court merely to apply well-established rules that limit the scope of local initiatives and referendum process. And these rules apply equally to everyone. They have been used to strike conservative and liberal initiatives. And this initiative violates numerous of those rules. I'll start with the Homelessness Act, and then I'll briefly touch on some of those other issues.
Counsel, can I ask you a preliminary question on appealability, which we did grant review on, and I know you did extensive briefing in the Court of Appeals, but I didn't see any additional briefing on that issue in our court.
That's right, because I think that the issue, the motion to dismiss before is sort of silly. This is a uniform declaratory judgment action, and the fact that one of the parties later submitted a non-reviewable petition, affidavit of election error, just cannot destroy the jurisdiction, and the cases say that.
Counsel, I don't mean to take you too far off point, but I was reading the materials here, and I wondered whether the this is a city or county ordinance?
City council.
City council had adopted this in some way that makes this case moot? I mean, clearly the city council could have made this amendment to the statute, to the ordinance.
Clearly, but no, nothing like that has happened that I'm aware of. And this case is not about the wisdom of the city council's policy. It's about enforcing state law, which does not allow the local initiative process to use to veto or amend the city council's decision on homelessness planning or to make any decisions about homelessness response. The legislature decided that homelessness policy is a statewide issue that would be decided by coordinated planning with plenty of input, with a final decision made by the city council.
Can I pause there and ask if you could define the difference between this type of a challenge, a subject matter challenge, not a substance challenge, and what might be a state preemption argument? Because if we look at how the initiative power operates at a local level, we typically look at the statute authorizes local initiative, and then we look at the charter. And here we have a pretty broad city charter authorizing an exercise of the initiative power to legislate. So if you're saying essentially that the state statute on this substance regarding policies toward the unhoused sort of occupies the field or something, that feels a lot more like a preemption argument than a scope of the local initiative power.
Well, and in fact, those two things are basically the same. That the courts has said that when the state passes a law that says we're going to use certain procedures for how we're going to make decisions on a particular subject, and then it can preclude the local initiative process. So it ends up being essentially a preemption. And the cases like Brisbane, Anderson, and 20 others basically say that when there is a conflict there between the state law and the local charter's initiative or referendum process, that in that situation the state controls. And
well, I think on pre-election challenges, what they really say is that the challenge is limited to the scope.
That's
the
true.
Initiative.
That's true. And
not the substance of the initiative, not its policy, not its the state's occupation of the field, but simply To whom was this power delegated, and is it administrative or is it legislative?
Yeah, there's sort of three, those are two of the three. There's basically the three big scope challenges. Two of them you said, and the third one is it consistent with state law?
That sounds like a substantive challenge, which would be outside of the scope.
Well, the scope challenges like Brisbane.
Outside of the scope of our review, not outside of the scope of the initiative power.
Well, this, of course, is no longer a pre-election challenge, but if you look at Brisbane and Anderson, yes for Seattle and
Oh,
such.
so your argument is that since it's no longer a pre-election challenge, we can consider all the substantive challenges to it?
Well, we haven't brought any constitutional challenges. We still are limiting to the scope, but one of the scope challenges that is recognized is whether or not it conflicts with state law. Essentially, what the
I'm aware
court
that
has
the
said.
Court of Appeals said that. I'm not aware of our precedent actually saying that.
Brisbane says that, Anderson says that.
But all of our other cases do a two-part analysis of scope challenges. To whom was the power delegated, the council or the people as a whole? And is it administrative or is it legislative?
Well, the GMA cases, Brisbane and Anderson, which the Court of Appeals did not talk about, but in fact are central here, one of the things it also says is it definitely looks at those two items, but it also says, was there a comprehensive planning process that was required, a coordinating planning process? And when there is coordinated planning required by the legislature, they said it is precludes local initiative and referendum because those two are antithetical to each other.
Does it preclude it entirely, Counselor? Does that get us into a conflict analysis?
Well, actually,
And the
it-
reason I ask that
yeah.
question is because if you're saying there's a sort of a preemption, occupy the field analysis, then the city council would be without any authority to do anything in conflict with that legislative or state direction.
Well,
And really, it's different than the initiative inquiry, although you said it's the same. And that's what, you confused me when you said that, because I'm not sure analytically they are the same.
Well, it's not exactly the same because we normally think of preemption as substantive, but in these scope challenges, like under the GMA, it is really about the procedure. So the state legislature has not said exactly how homelessness must be addressed, but it did say three things. It said that there must be coordinated planning between the state and the local. It said that there's going to be plenty of input, but it didn't include the initiative or referendum process. And then it also said that the city council will make these final decisions. And so it preempted how the decisions are made, but not necessarily the substance of them. But your point is an important one, is that does there need to be a conflict? The cases have not said that there needs to be a conflict. And there's so it is more like a field preemption. And there's a reason for that. And that's because it's not just about what the city council has done in the past. It's also about that the legislature has given the city council discretion to make a decision in the future. Like, for example, the state has done its 5-year planning. We've given you all that information. Soon, it will turn to the local government, and the city council is going to need to do a plan that is consistent with the state plan. If a local initiative could essentially say, you can't do certain things, if it was to remove certain types of homelessness housing from the toolkit that the city council has, then it could easily make it so that the city council cannot exercise the discretion that the state legislature tried to give them.
But take, for purposes of my question, take the initiative out of this and put the act, as Justice Bradson suggested, in the control of the city council, that they enacted a similar or exact ordinance. Then do we get into the conflict analysis?
No. So this case is not about what the city council can do. So the city council can, for example, absolutely ignore the directives under the act. Then it would be a different case. there are certain things that could happen, including removing of homelessness housing funding from the city. But it is the city council's decision. What you don't want to have is a situation where the city council wants to stay in compliance, like we think that that's the case here, and a local initiative comes in and essentially takes the city out of compliance or prevents it from enacting a plan that is consistent with the whole coordinated planning process.
So following up on that, can I ask you to turn to the administrative versus legislative inquiry that we do?
Sure. Well, as we know, that is sort of a squishy thing in some of the cases. But here, the legislature itself said that this is going to be an administrative issue. And for example, 43-185C-1010 said, defined the homelessness housing program to mean the program authorized under this chapter, quote, as administered by the department at the state level and by the local government or its designated subcontractors at the local level. In other words, this wasn't an entire lawmaking process. It was a process where the legislature said, we're going to have this homelessness housing program. It's going to be administered at these two levels.
I thought the administrative legislative inquiry is the initiative tinkering with an already existing local ordinance and structure for achieving whatever the particular end was.
Yes.
Reducing drug abuse or whatever it is.
Yes, the court has found the violation of that administrative distinction in several ways, and both of them apply here, including the fact that the city council struggled with an issue, made a decision. This would reverse it, and under the court's precedents, that is also, does turn it into an administrative issue.
I have a question, and maybe I just have a very simple understanding of the difference between local and state initiatives.
Mm-hmm.
If the legislature can do it statewide, then the people can do it by initiative. Is that true?
No. So the statewide initiative process has basically an unlimited scope. It's constitutionally protected, whereas the local initiative process.
Did you hear my question, though?
I thought I did.
If the state legislature can do it, the people can do it by initiative.
On the statewide level.
On the statewide,
Oh,
that's what
yes.
I'm asking.
Yes.
But on the local level, just because the city council can do it doesn't mean that the people of the city can do it.
That is correct.
And why is there a difference?
That's where I got back to my answer. That on the statewide level, it is a constitutionally protected right, and it has basically unlimited scope. The court has said on the local level, because initiatives are a creature of statute, that it can only be used where it is on a purely local issue and it is consistent with the other body of state law.
And so I haven't found very many examples of where we've said an initiative is actually within the scope of the power of the local initiative. So there are many cases where we say, yeah, that's okay. Why is that?
Well, I think what happens is that the cases of local initiatives, it is very constrained, the local initiative right, and the cases that come to you are the ones where the people didn't follow the rules, like this one.
And what is the analysis then? Do we start with the admin legislative distinction? Is there a
It's
series of the
basically,
tests?
I would say it's three parts, and, Brisbane and Anderson kind of lay it out, but others do as well. But it would really start with these three issues, with whether it is administrative or legislative. It would also be whether or not the state legislature had set up a comprehensive scheme for decision-making or coordinated planning, and that the local initiative process would be inconsistent. And then the third is whether or not the legislature has specifically delegated one of these, some of this power to the city council. And I would say the city council, here, I would really say that this is controlled by Brisbane and Anderson. When the legislature passed the Homelessness Act, it had been 10 years since this court had decided that the GMA precluded the initiative process. And it did it because of these three reasons. And the legislature is presumed to know that limitation. And yet it followed the GMA in all three of those issues that this court relied upon in Brisbane and Anderson. So essentially, the legislature was making a decision to do what it needs to do to allow homelessness to be addressed without interference from the local initiative or referendum power.
You said there are three parts to the test, and you gave them in
Well,
order.
Those are they're not necessarily in order. Like, basically, there are three independent hurdles, and if the initiative fails to address and surpass any of those hurdles, it is invalid.
How
And
many of those hurdles does this initiative get over?
it gets over zero of the three.
So, counsel, if you took state law out of the equation, which is this sort of encompassing collaborative process that the state legislature would like to go through, like to have communities go through, take that out of the equation and you have a criminal law, like the Court of Appeals here said. It's a vagrancy law. That's how they described it. Would the City Council have been within its authority to pass this legislation as a legislative body, as legislation, not as an administrative plan or procedure?
Well, I believe this court has other cases that are coming before it about the protections for people who are unhoused. And, frankly, that's not part of this case. But I would say that it's important to keep in mind that the people who are unhoused are parts of our community and are in crisis. Here, it really is about, since this is a scope case, it really is about the limited power of the local initiative process, and that's because the state legislature has decided that that we're going to tackle this issue as a state, and it passed this coordinated planning. It required evidence-based research, best practices, and that the city council will make this decision, and it did it so that all parties would be, all levels of government would be sort of rowing in the same direction on this issue. And once it does that, it followed the GMA and your court's precedent to say that that process cannot be interfered with by the local initiative or referendum process.
Thank you.
Thank you, Your Honor.
Response, please.
Good morning. May it please the court, Mark Lamb of Carney Badley Spellman representing Brian Hansen and Citizens for a Clean and Safe Spokane. There are, first of all, two issues in front of the court. One is that the Superior Court's decision is final under the ballot challenge statute. The second is that the law that is at issue here is a proper use of the city's broad police power, which the people may exercise by initiative. I'm going to address the first issue that I raised first. The motions at the center of this case, that the trial court's oral ruling on those motions, and most importantly, its final written order on that motion, all explicitly state that the matter was decided under RCW 29A 68011, which is the prevention and correction of ballot frauds and errors. The appellant does not contest that decisions under RCW 29A 68011 are final, meaning that they cannot be appealed. The appellant has offered no briefing on this issue for this court.
Well, it was briefed extensively in the Court of Appeals, and we can look at the Court of Appeals briefing here. And I think their answer is there were two claims in the complaint. Claim 1, declaratory relief. Claim 2, injunctive relief. There wasn't even a separate claim under 29A, although it was cited as a basis of jurisdiction. So then Stuttgart files the declaration that triggers the 29A timeline. He doesn't get the benefit of the 29A timeline. and we're post-election. So we're still left with a DEC and injunctive relief claim, aren't we? And
No.
isn't that how we've always reached questions like this, like in Freed, post-election?
Well, I think it wasn't at issue in Freed, and I'm familiar with Freed, and it was not at issue at Freed. The fact that they invoked the statute of 011, I think is important, and I'll tell you why. Because if you look at Hatfield versus Greco, that's the issue, is saying what was the intent of the legislature. The intent of the legislature in 011 is to provide for a speedy determination of an emergent matter, which is deciding what needs to appear on the ballot. In this case, they did achieve the benefit of a speedy resolution of this. It was
Well,
not
they didn't
within.
issue it within 5 days, as the statute requires, and
Well, I take your point, but I would say, look, for example, in the recall statute, it says it has to be decided within 15 days. Routinely at the trial court, I can say, having litigated a number of those issues, it's not resolved within 15 days, but it's resolved promptly. In this case, it was resolved in time enough for the determination to be made by the ballot, and it was decided in time enough for them to file an appeal before Division 3, and Division 3 actually reached a conclusion before the ballot. So I think the issue is, as a matter of policy, did the state legislature want scope challenges to be decided under 011? I would argue in terms of legislative initiatives, they did not, but having invoked it, I think you don't get to say I have a heads, I win, tails you lose proposition where if I like the result of the trial court, as opposing counsel has done before, and said, look, I'm going to say it would disrupt the process if we were to continue. You can't rush into court, demand an emergent hearing, and then not accept what the result of the statute says, which is clearly that it's
well,
final.
it was Stuttgart that demanded the emergency hearing. It was
But
not
they were-
Jules.
No, that's a fair point, Your Honor. Both of them, but Jules did as well. The motion that's at issue and the motions before the court was a joint motion. Both of them asked for it, and both of them cited 011. It was not simply Stuttgart he submitted the affidavit. Both of them sought relief under this. Both of them received a highly expedited treating. They didn't have to do so. They could have just made a motion to shorten time on a declaratory judgment. They strategically chose the faster procedural path, and having done so, you have to take the bitter with the sweet. And to be clear on this point, if this court doesn't hold that, then you completely vitiate the election statute, that there is finality with that. If you say, well, if you simply cite the declaratory judgment action, you join it as a joint motion, there is no longer any finality in this rule, because everybody will say, okay, if I just cite the Uniform Declaratory Judgments action, I get another bite at the apple. I can get not only this hyper expedited review, not a motion to shorten time, but a statutorily mandated pre-election review. Plus, if I don't like the result, I get to dispense with the clear, plain language of the statute, which is undisputed, that it's final. And then I get my second bite at the apple. I think if this court holds that, respectfully, Division 3 said we're not going to reach that issue because I think you win on the merits. If this court holds
How
that,
can you not reach the issue and then get to the merits? How can you not reach the issue of whether the case is properly in front of the court and then get to the merits?
that would be a great question for Division 3, Your Honor. But I would say that in this case, the court does not need to reach the merits. In this case, this matter, under the statute, under the plain language of the statute, under Hatfield versus Greco, was finally decided by the Superior Court, and the matter should be left there. I think to hold otherwise is to invite, candidly, what opposing counsel has done quite creatively and strategically throughout the state, which is to come into litigation, highly sensitive public policy litigation, at the last minute, and to come in and wait and then get this highly expedited procedure.
Doesn't it have the result of, through the back door, expanding the local initiative power if the trial court's ruling was wrong, even if final under the statute?
I totally agree with you, Justice Gonzalez. And actually, in Division 3, Judge Parnell brought that up to me. She said, well, wait a minute, I read 011, and that's not, as I read it, it's not even proper to bring an initiative challenge under 011. And I sort of foolishly and flippantly said, well, that's a question for opposing counsel. That's not my issue, it's his issue, because he's the one who raised it. She was right and I was wrong. 011 should not apply to the initiative. And it is critically important for this court, if you hold that the Superior Court decision is final, you need not reach the issue of whether or not 011 applies to initiatives. Historically, it does not. The legislative, not to bore the court with the legal history of it, but the legislative predecessor to 011 was passed in 1889, which was before our state even had an initiative process. Every part of 011 contemplates that it will only deal with a candidate issue. There's no reference to a ballot. 013 does reference a measure, but there's no reference in 011 to any initiative process, and historically, the legislature has never included that. 011 makes sense when you're like, look, we just had a situation with the lands commissioner race, where it's a very close race. Two people have to be on the ballot. There has to be a decision made. Under federal law, ballots have to be sent out by a certain date. So there is an emergent nature, there's an emergent need to get that issue on the ballot.
Counselor, this is my last question on this topic. Parker versus Wyman, 2012, is one of the earlier cases that said decisions by the Superior Court are final under 29A 011. But they went on and reached the merits, didn't they?
And that is that's the indulgence that I think the court has, and I think this court can do so as well. You don't have to reach the merits, and I think that may, to answer your earlier good question, I think, Your Honor, that may be why Division 3 did what it did. It may have said, hey, we don't want to wade into this procedural aspect of 011 because there may be implications. It would kind of vitiate the finality rule of 011 if we do so. We believe that you win on the merits, and so ergo it's moot. And I think that may be very well be why Division 3 reached the conclusion that they did. Your Honor, you had a question? Okay. So moving then on to, I think, the substance of this, which has to do with, I'll take the arguments kind of in sequence. The appellant has argued that the homeless housing initiative is akin to the Growth Management Act, and the Growth Management Act precludes local, initiatives and referendums. But I think it's important to understand that the two laws could not be more dissimilar in terms of both their procedural layout and what their goal is. The goal of the Growth Management Act is to generate laws, ordinances, and regulations that implement state policy with respect to growth management, with respect to the treatment of critical areas, with respect to the prevention of sprawl. And there are very specific policy goals that are set out that are prescriptive, that the city council I served on the city council. We don't have the authority to say, well, we like big lots. We don't want to have, density here. We don't want to take certain activity. We don't want to take certain land uses that we don't like as a city. The state says, well, wait a minute. If every city did that, we wouldn't have any of the purposes that we've articulated in the growth management.
Can I ask, related to that, I made this assumption, but I want to know if I'm misreading it. Parts of the ordinance as originally enacted and actually throughout here deal with critical areas or railroad rights-of-way, et cetera. Are those reflecting GMA requirements insofar as designating areas where camping is not allowed?
So they're not, Your Honor, because that's not the process that they went through, and that's a great question. With respect to the GMA, you go through a deliberative process. You go through a planning process with a planning commission. They then have to make certain findings and facts of law and conclusion. This is the specific place in the Spokane Municipal Code where this ordinance lies, deals with camping, littering, and burning. There are three issues that are sort of addressed in that body of law, and it's all dealing with how public spaces are dealt with. This is how individuals conduct themselves in public. If an individual burns an item in public, if an individual litters in public, or if an individual camps in public, that is dealt with through this aspect of the code. And that is appropriate. Yes, Justice.
Just wondering how the city arrived at these categorical prescriptions. Was it through the collaborative process that was required by state law?
It was not, Your Honor. It was not, Your Honor. It was done through the police power, and that was cited specifically in the record, and it's cited specifically in how it was adopted. There was no use of this collaborative process. It did not come up through the Homeless Housing Planning Commission in Spokane or in Spokane County. And in fact, if we look at what those statutes actually say, the individual conduct issue that is addressed in this case is not viewed by any of those, either by the Spokane Plan, by the Homeless Housing Act, or by the Ruckelshaus Report as a good to be subsidized and encouraged. It is viewed as something that is a problem to be reduced and a problem to be addressed. And indeed, that's what this law does. This law says not that people who are camping within 1,000 feet of a preschool or of a park or of a school are going to be arrested and incarcerated. It's a means of getting them into the system and to getting them help and to getting them alternative services.
Let me ask you
and that's
whether
provided
it's-
for. Yes, ma'am.
I'm sorry. Let me ask you whether it's impermissibly administrative rather than permissibly legislative. I think that was the topic where the hearing examiner had a question, and it was the topic where the Court of Appeals said, that's a pretty good argument, and it might be administrative, but we're taking this other path and not calling it administrative. Why is this not administrative under the fluoride case from Port Angeles or under the street names change out of Seattle?
So I think in here, I would say that it is precisely because of what the statute does and doesn't do. The change was only 27 words. The change had to do with the scope of the law itself as to the locations that it applied to. There's an extensive provision of how it is to be administered that I was just referring to a moment ago, which is when you encounter someone who is unhoused, how does law enforcement deal with that person? What are the different requirements in terms of the availability of shelter, in terms of how you would process that person once incarcerated?
That sounds administrative.
Those are all administrative, and those are all untouched by this initiative, Your Honor. So those portions of this law were untouched by this initiative. If this initiative had said, hypothetically, any policeman who encounters this person, we're going to create up a different administrative process where they have to deal with it. That would be administrative,
Well,
not
essentially
legislative.
says any police officer who encounters a person within 1,000 feet of a school or of a park gets this particular treatment, whereas under the city council's comprehensive plan, they would have gotten different treatment.
I don't think that's accurate. I think what it says is that the scope, there was a never camp zone, which includes the entirety of the city under Spokane law. After the Martin decision, that was then modified to say it would be dependent on the availability of shelter. Then there was an exception to
And
that exception
locations.
that was made. This is only dealing with the exception of the exception. This does not address how police address it, whether police enforce it, how they would do
Well,
it.
I agree with you that it's
Yeah.
dealing with an exception to an exception. That sounds really administrative to me
I
under
think
our
that-
test.
No, I appreciate it. So, I mean, let's go back then to a moment for the cases that you talked about. Let's look at the fluoridation of water case. That's one where the water district was specifically authorized by statute to say you will make that decision. The water district gets to make that decision. Nobody else gets to make
Well,
that
that's a to
decision.
whom delegated issue. The fluoride case was decided also under the administrative versus legislative issue, and they're two separate inquiries.
I think they are. I mean, I do want to say for the record that I believe this issue was waived and that it was not raised on appeal by the legislative administrator, but of course the court can reach the issue as well.
It was raised in the Court of Appeals. The Court of Appeals addressed it, and we granted review on the petition for review.
I'm sorry, Your Honor, you're absolutely correct. The petition for review did not raise the administrative legislative distinction to this court.
Not explicitly, but okay, I hear you.
Right. So I think that let's take our water, our choice. In that case, they decided under the city's existing water management plan to fluoridate its water. The Supreme Court affirmed in a declaration the two initiatives more than 3 years later were administrative in character because they sought to administer the details of the existing water plan. Here in the code that is at issue, you have the law, which is where can you camp under the criminal code and where can you not camp? It's a misdemeanor to camp here. It's not a misdemeanor to camp there. You then have enabling legislation that talks about how that is implemented, how that is administered. That's completely untouched by this. The only part of this initiative, and this initiative, unlike all of those initiatives, is quite simple. It's only 27 words, and it deals squarely and only with the geographical areas where this can be enforced. It has nothing to do with administration, everything to do with legislative policy. So,
Can I take you back to, I want to zoom back out to, you're saying this isn't like the GMA cases, but I'm not sure the argument has to be that this was that the city's ordinance was effectuating the GMA, but that the housing, what are people calling it, the HHA or the
HHA,
is akin to the GMA in that it sets out a comprehensive scheme and relies on local jurisdictions to develop specific enforcement regimes to effectuate that scheme. So maybe you could address that more directly and park whether the GMA is at issue. And maybe that's where you were going, but my
Yeah,
question asked you more about the GMA directly. I want to really know about whether the HHA is akin to the GMA in its operation.
Yeah, and that's a helpful redirect. I appreciate that, Justice. The issue of the HHAA is that it is trying to get good ideas about solving a problem that has plagued our state for some time. It is trying to generate ideas at the local level. It does not have, unlike the GMA, it doesn't have policy mandates as to what results should be reached. It is about getting money, frankly, from the Department of Commerce to local jurisdictions to try to house people who are unhoused. That is the essence of the HHA. It does include a process to include stakeholders in terms of how that grant money should be distributed, and the only stick that is involved in this is whether that money is distributed or not, whether that money is taken back from the state or not. That is completely dissimilar from Brisbane and the entire line of zoning cases and land use cases where the state has very specifically carved out a place for those decisions to be made. I also think it's instructive that, unlike the GMA, and this doesn't even delegate it necessarily, and this came up at the trial court, to the city council. It repeatedly references the city, which under controlling case law of this court means the city as a whole, not specifically the city council. So my feeling is, we're looking at it's comparing apples to oranges. It's saying a statute that is, began with the aspirational goal of ending homelessness in Washington in 2015 and is searching, as we all are, for good solutions to try to find that. It doesn't deal with the criminal code. Nowhere in the HHAA does it say cities are prohibited from developing, a criminal response or to banning littering, burning, or camping. Nor does it say that camping is a social good that needs to be encouraged. It talks about encampments, which are, for example, when religious associations host encampments or when they're hosted in an organized manner. That's a completely different question than whether an individual makes a decision to camp under, within 1,000 feet of one of these protected areas. I do think it's important to note, and this is in the record as well, that the reason this came about was because the plaintiff did operate a homeless encampment that had enormous problems with drugs and violence. You had a 65% increase in crime around that area, and you had drug activity, sexual activity, and violence, arson, right around a school that was located very close to that encampment. That is problematic. That is something that the citizens of Spokane have a right to legislate on. And I think that when you look at Chief Justice Gonzalez brought up a good point regarding, it seems like we don't get many of these cases where the people win, where the people have an opportunity to legislate on that. I think there are good cases that involve that. One of them comes, honestly, from the city of Spokane, which is the Citizens for Financially Responsible Government versus the city of Spokane at 662 Pacific 2nd, 845. That case holds that you have the legislature has delegated certain powers, in this case, police powers, to the city as a whole, not to the city council. When the citizens have that, they have a right under Spokane's charter that it subjects all power of the city to the direction of the people by initiative, referendum, and recall. At all times, all power exercised by that city is concurrent with the citizens of that city. And in all of these analyses, you have to look at state law, and then you have to say, how does this intersect with the incredibly broad powers that are given to the people of the city of Spokane? So that is our, and I see that my time is now up. What we would ask this court to do is to affirm the Division 3 decision, which is well-reasoned. In the alternative, as I argued at Division 3, I don't know that this court needs to reach that. I believe that it's clear under the existing case law of this court, including the Greco decision, that the order of the Superior Court was final. Whether or not it was proper to be brought in the first place as a review of the initiative power, I would argue that it is not, but the ultimate decision was final and unappealable when entered by the Superior Court, and that should have concluded the matter.
Thank you.
Thank you, Your Honor.
Rebuttal.
Thank you, Your Honor. Just and appreciate the additional time. Just a couple quick points. Encampments are within the Act's planning scope. The Homelessness Act defines homelessness housing to include encampments. It's sort of a pragmatic decision about where we are right now. The Act's planning process explicitly addresses encampments, and they're addressed by the Ruckelshaus report, the new draft 5-year plan, and Spokane's previous 5-year plans, which are all before the court.
Does it matter if the city ordinance was passed under the police power or under the statute?
No. Under Yes for Seattle, for example, it said absolutely not. But so, because we don't know exactly, so no. In fact, Yes for Seattle specifically says once you're talking about within the scope of the issues, it doesn't, the issues that the legislation addresses, it doesn't matter. You can't essentially do an end run, because then the initiative, for example, could just run an initiative that says that you're going to preclude something that you see coming down the pike, for example. As we've shown in the outline that I just handed to you, this is a very complex process, and there's a lot of resources being put into it, and it's really easy on the local level to see what the Ruckelshaus report is saying, what the state plan is doing. If you could just run an initiative preemptively to essentially take things away from the toolkit that the city council is supposed to use to solve this problem, well, then a local initiative could undermine the plan either by taking away the ability to do housing or just bringing the city out of compliance so that the money no longer flows.
As to the legislative administrative issue, to the extent that's the inquiry, could the city council make that decision? We understand the state plan, and we understand everyone wants to be under the state legislative policy involved in solutions. And the city council says, but not Spokane. We don't want to be part. We just will forego any funding. Could the city council make that decision?
Well, that's a different case, but I would say that this particular body of cases that we're relying upon here are a limitation on the initiative process out of respect for the legislature's express delegation to the city council.
So have you abandoned the administrative versus legislative argument?
Oh, no, that was within the main point, which is the scope. And for the reasons that Your Honor has brought up, for both of the reasons that we spoke about, that it is also administrative. This gets through none of the 3 hurdles that we've talked about, and for that reason, we would ask that Your Honors overturn Division 3 and hold that, like the GMA, the Homelessness Act represents our state policy to allow coordinated planning and evidence-based decision-making as the guideposts for this process. Thank you.
Following these arguments, the court disagreed and reversed the appellate court's previous decision. The court determined the initiative details Spokane's pre-existing policy approach to camping and is therefore administrative, rendering this initiative as an exceedance to the proper scope of the local initiative power. What do you think about this conclusion? Is there another action the government should be taking to deal with homeless encampments within the city of Spokane? Let me know what you think in the comments below. And if you like this video, please hit subscribe for new arguments every week.